court is constituted and may be extended or restricted by like means. We emphasize that if no restriction or limit is imposed, the jurisdiction is said to be unlimited. The quotation goes further, but that is the emphasis statement. It is undisputed that the impeachment of the Deputy President is a constitutional process outlined in Article 145 of the Constitution. The authority to determine whether the merits and procedures of such an impeachment process align with constitutional requirements, therefore falls squarely within the jurisdiction of the High Court as provided for under Article 165(3)(2). The role of the courts in an impeachment process was reiterated by the Supreme Court in the case of Sonko versus Clark County Assembly of Nairobi. That is another quotation that we have reproduced in our ruling when we get to read it. The court went on to state that the impeachment architecture in the Constitution, the law, and the standing orders leaves no doubt that removal of a governor relates to accountability, political governance, and personal responsibility, and not necessarily about criminal responsibility. It follows that insofar as the process of removal of a governor from office is concerned, the court's role is confined to deciding whether the governor's constitutional rights and fundamental freedoms have been breached in the process and whether the procedures for removal from office have been followed without the court constituting itself into any of the two constitutional organs in whose hands the power to remove is vested. While we acknowledge that this referenced decision pertains to the impeachment of a governor, we maintain that the same constitutional principles apply to the impeachment of a deputy president. And accordingly, we do hereby find and hold that this court has the jurisdiction to sit and determine the matter that is before it.
The second issue is whether the matters raised in the consolidated petitions are justiciable. Ordinarily, an application for conservatory orders concerning the subject matter of a suit is relatively straightforward, as the law in this area is well established. However, the current applications before the court are far from routine. These applications are imbued with political maneuvering between the applicants and the respondents. In essence, power struggles involving other constitutional organs have been brought before this court for a legal solution. As a result, this court has become the stage upon which political excesses are to be examined and resolved. Inevitably, such cases evoke intense emotions. The impeachment case of the first petitioner currently before this court exemplifies the dilemma faced by the judiciary when handling cases that straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue, one that has significant implications for the doctrine of separation of powers among the three arms of government. Answering this issue requires a brief analysis of the doctrine of separation of powers in relation to the doctrine of justiciability. French political philosopher Montesquieu first formulated the doctrine of separation of powers through his seminal work, L'Esprit de Louis, in other words called the Spirit of Laws, which was published in 1748. Montesquieu argued that such separation limits the possibility of arbitrary excesses by the government, since the sanction of all three branches is required for the making, executing, and administering of laws. The Constitution of Kenya 2010 clearly delineates the three arms of government, each with its own distinct personnel and roles, as set out under chapters 8, 9, and 10. Chapter 8 establishes the legislature and details its composition, functions, and powers as the law-making body of the government. Chapter 9 outlines the structure, the functions of the executive, whose primary role is implementing and enforcing laws and policies. Chapter 10 focuses on the judiciary. It defines the structure of the courts and lays out the judiciary's mandate as the arbiter of disputes and the guardian of the Constitution, tasked with interpreting and applying the law impartially. While the provisions regarding judicial power under Chapter 10 of the Constitution are clearly defined, the political question doctrine, also referred to as the non-justiciability doctrine, highlights the limitations on the judiciary's role in adjudicating matters that fall within the purview of other branches of government. This doctrine essentially asserts that certain issues are not suitable for judicial determination because they are better addressed by the legislative or executive branches, which have the constitutional mandate and expertise to handle them. Black's Law Dictionary, 10th edition, at page 943 to page 944, defines justiciability as a matter that is, in quote, proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision, close quote. There is an abundance of judicial pronouncements expounding on the doctrine of the political question. For instance, in Marbury versus Madison, Chief Justice John Marshall established the principle that while the courts have the authority to interpret the law, certain political questions are outside the scope of judicial review. The case underscored that where the Constitution assigns duties to other branches of government and does not provide standards for the judiciary to assess those duties, the matter is deemed as non-justiciable. Closer home, in William Odhiambo Ramogi and two others, versus Attorney General, a 5-judge bench observed as follows: the justiciability doctrine is rooted in both constitutional and prudential considerations and evinces respect for the separation of powers, including a properly limited role of the courts in a democratic society. One justiciability concept is the political question doctrine, according to which courts should not adjudicate certain controversies because their resolution is more proper within the political branches. In Baker versus Carr, the United States Supreme Court outlined 6 matters that could present political questions as follows. 1, a textually demonstrable constitutional commitment of the issue to a coordinate political department. Or 2, a lack of judicially discoverable and manageable standards for resolving it. And 3, the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion. 4, the impossibility of a court's undertaking independent resolution without expressing lack of the respect due to coordinate branches of government. And finally, an unusual need for questioning adherence to a political decision already made and the potentially of embarrassment from multifarious pronouncements by various departments on one issue. Additionally, the Court of Appeal in Kenya Airports Authority versus Mitubel had this to say: with this in mind, the role of the legislature is to make laws and policy, and that of the executive is to implement those laws and policies. The role of the judiciary is to interpret the policies and laws as enacted and approved by the legislature and the executive. Generally, courts have no role to play in policy formulations. Formulation of government policy is a function best suited for the executive and legislature, close quote. In Kiriro versus Ngugi, a 3-judge bench had this to say: a court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. The doctrines are cross-cutting and closely intertwined. We shall, however, endeavor to, as far as possible, delimit the operation of each doctrine in isolation. Close quote. This bench starts with determining whether the issue of the impeachment of the deputy president falls within the category of cases where the concept of non-justiciability would prevent this court from hearing and deciding the matter. The essence of this question lies in assessing whether the political question doctrine would apply, thereby barring the court from intervening in what might be considered a matter reserved for legislative or executive branches under the Constitution. Learned counsel Dr. Thiankolu relied on the U.S. decision in Nixon versus United States to argue the case that the dispute before the court is a political question and hence non-justiciable. We have given due consideration to this decision, noting that it pertained to a dispute involving the impeachment of a Chief Justice of a federal district court in the United States. In resolving the matter, the district court held that it lacked jurisdiction to hear an appeal from the Senate regarding the impeachment of the chief judge, deeming the claim non-justiciable. In determining whether a dispute is non-justiciable, the court held that the test depends on whether, in quote, there is a textually demonstrable constitutional commitment of the issue to a coordinate political department or a lack of judicially discoverable and manageable standards for resolving it. The question to ask, in simple terms, is whether the 2010 Constitution specifically assigns the sole responsibility for resolving disputes arising from the impeachment of the Deputy President, as in our case, to another branch of government. Additionally, are there clear legal rules or standards that a court can apply to reach a fair and just decision on such matters? Within the context of the American system, and as articulated by the court, the learned judges answered the first question in the affirmative. They held that Article 1, Section 3, Clause 6 of the U.S. Constitution demonstrates a clear textual commitment of the impeachment process to the Senate. For clarity, this clause, known as the Impeachment Trial Clause, states, in quote, the Senate shall have the sole power to try all impeachments, close quote. We previously referenced the pre-2010 Constitution drafts that were brought to our attention by Dr. Thiankolu. What is evident from this text is that the people of Kenya clearly intended for the impeachment process to be a justiciable matter. This conclusion is supported by the fact that each constitutional draft contained provisions affirming this intent. This position is unsurprising when considering the historical context in which the Constitution was created. The people of Kenya sought to move beyond a past where the judiciary was often marginalized or bypassed in efforts to check governmental excesses. Instead, they envisioned a new constitutional order in which all branches of government would be held accountable and subject to comprehensive constitutional oversight. This aspiration was central to establishing a balanced system that ensured no arm of government operated beyond scrutiny. We are therefore not convinced, against a holistic reading of our Constitution, that there was any intention to deliberately place the impeachment power on the legislature with no judicial involvement. To hold otherwise would be to create an absurdity whereby the dictates of the Constitution under Articles 23, 160, and 165, 3D2 would be defeated. In our view, this decision is further distinguishable by the fact that the appointment of judges in the United States and Kenya differs significantly due to unique political structures and systems of government. Judicial appointments in the US are more overtly political, with the President and Senate playing direct roles. In contrast, Kenya's system emphasizes judicial oversight through the Judicial Service Commission, which is designed to limit political influence and promote greater judicial independence. Going back to the question that we posed previously, it is clear that unlike the US position, there is no textually demonstrable constitutional commitment of the issue of impeachment solely to any political department or institution. Drawing analogies, the fact that the American context states that the Senate sits to solely try impeachment disputes is a major departure from the 2010 Constitution. Even though the requirements for the two-thirds vote and the taking of an oath are identical, the procedure and provisions of the Constitution, as we have spelled out, leave no doubt that the Senate is not the sole determinant of the dispute. We have already expressed ourselves succinctly on the jurisdiction that has been conferred to this court under the Constitution in our previous decisions. It is now well settled that there are instances in which the courts will and should interfere with political processes. A few decisions suffice to demonstrate this position. The Court of Appeal in Martin Nyaga Wambora and three others stated as follows at paragraph 62, the political question doctrine and the concept of separation of powers cannot oust the jurisdiction of courts to interpret the Constitution or to determine the question if anything said to be done under the authority of the Constitution or law is consistent with or in contravention of the Constitution as per Article 165, sub-Article 3D2. Equally, as we have seen in the case of William Odhiambo Ramogi, the court stated that there are constitutionally permissible situations where this court may interfere in the policy decisions of the government, and particularly if a policy decision is in equal or in actual or threatened violation of the fundamental rights guaranteed under the Constitution or in violation of other provisions of the Constitution. The necessity of vindicating constitutionally secured personal liberties and fundamental freedoms is the principal justification for the anti-majoritarian power that judicial review confers upon the courts, and we are therefore reluctant to find that a claim of fundamental rights, such as the one presented by the petitioner, is non-justiciable, even though it may concern the political process or the internal workings of other government branches. Close quote. The crust of the petitioner's case centers on key questions, including whether the process was followed by the National Assembly and the Senate in the impeachment of the first petitioner, and whether the first petitioner was afforded sufficient time to prepare his defense against the impeachment charges. These issues strike at the heart of constitutional and procedural fairness, raising concerns about the extent to which legislative bodies adhered to the standards of due process as outlined in the Constitution. The petitioners contend that the impeachment process must align with the constitutional principles of fairness and justice, ensuring that any office holder facing such proceedings is provided with a reasonable opportunity to respond and defend against the charges. This court is therefore called upon to examine whether the procedural safeguards required by the Constitution were observed during the impeachment process, and whether any potential lapses could render the process flawed or unconstitutional. Such an inquiry will involve a careful review of the actions taken by the National Assembly and the Senate to determine if the principles of due process and fair administrative action were upheld. We take the view that, based on a holistic reading of the 2010 Constitution, the political question doctrine cannot oust this court's jurisdiction as granted under Article 165, sub-Article 3. Article 165, sub-Article 3 confers upon the High Court the authority to hear and determine questions regarding the interpretation of the Constitution and the legality of any acts or omissions by state organs. This provision underscores the High Court's critical role in ensuring constitutional compliance, even in politically charged matters. The Supreme Court of Kenya in Sonko case supports this position in its holding that impeachment proceedings are inherently political. They do not fall beyond the scope of judicial review. The court stated as follows. It's a fairly long quote, I've given it. In Martin Nyaga Wambora versus Speaker of the Senate, the Court of Appeal also held that judicial intervention in impeachment must be exercised cautiously. While conservatory orders may be issued to protect constitutional rights, they should not encroach upon the legislative process unless clear evidence of constitutional or procedural violations exists. The court underscored that judicial intervention should respect the separation of powers, ensuring that the judiciary does not undermine the functions of elected bodies. South African courts have similarly addressed the scope of judicial intervention in impeachment process, emphasizing the balance between constitutional oversight and respect for the separation of powers. A notable example is Economic Freedom Fighters versus Speaker of the National Assembly and others. This is a 2018 matter which involved impeachment proceedings against former President Jacob Zuma. In this case, the Constitutional Court affirmed that while the judiciary has the authority to ensure that impeachment proceedings comply with constitutional requirements, it must exercise restraint to avoid encroaching on the disciplinary functions of the legislature. The court made it clear that judicial intervention is warranted only when necessary to correct political procedural irregularities or constitutional violations. The ruling highlighted that conservatory orders should be applied with caution to prevent unwarranted intrusion into the legislature's domain. The court had this to say, in quote, "Courts must be careful not to impose themselves in a matter that disrupts the legislative process or undermines the authority of Parliament. Judicial oversight is essential to safeguard constitutional rights and ensure procedural fairness, but it should not extend to directing how the legislature carries out its internal disciplinary proceedings unless there is clear evidence of procedural defects or breaches of the Constitution." This decision underlines the principle that the judiciary's role in impeachment matters is not to take over legislative functions, but to ensure that such processes are conducted in a manner that respects constitutional norms and procedural fairness. It reinforces the idea that while the doctrine of separation of powers is crucial, it does not preclude judicial oversight when fundamental constitutional principles are at risk. It is therefore our finding, based on the above, that the Constitution of Kenya has clearly delineated independent and distinct paths for the three arms of government. Accordingly, this court's intervention in the matter before it is warranted through a very narrow window that allows for oversight in cases where constitutional infractions are alleged in the impeachment process. This position is reinforced by our previous determination that the petitioners have established a prima facie case in the petitions before this court.
And I will handle the third issue, that is whether the conservatory orders in place should be confirmed. We reiterate that we dealt at length with the nature and principles for consideration in application seeking conservatory orders. That was in ruling number 1, which we delivered some few days ago. We adopt that discussion as part of this ruling by your reference, and suffice to say that the three main principles for consideration are as follows. The first one being that the need for the applicant to demonstrate an arguable prima facie case. The second, whether the public interest will be served or prejudiced by a decision to exercise discretion to grant or deny a conservatory order. And the third is that whether, if an interim conservatory order is not granted, the petition or its substratum will be rendered nugatory. We will consider the said principles as they play out in this matter. On whether prima facie case has been demonstrated, this is a discussion which featured in ruling number 1, where we dealt with the definition and the nature of a prima facie case. We held that such is a case which, and I quote, on the material presented to court, a tribunal properly directing itself will conclude that there exists a right which has apparently been infringed by the opposite party as to call for an explanation or rebuttal from the other, end of quote. See the case of Rao versus First American Bank of Kenya Limited and 2 others. In the said ruling number 1, we went further and said, I quote, in sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law. In doing so, a court must be guided by Articles 22, Sub-Article 1, and Article 258, Sub-Article 1 of the Constitution, which provisions are on the right to institute court proceedings whenever a right or fundamental freedom in the Bill of Rights has been denied, violated, or infringed, or is threatened, or when the Constitution has been contravened or is threatened with contravention, end of quote. Upon being satisfied, this court, in the said ruling number 1, rendered itself as follows. I quote again. Applying the above in this matter, and without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration, end of quote. This court has not deviated from the above position. We reaffirm that the consolidated petitions in cohort number 1 and in cohort number 2 still raise constitutional issues requiring further judicial interrogation. The second issue is whether with public interest considerations. Black's Law Dictionary described public interest as the general welfare of a populace considered as warranting recognition and protection, something in which the public as a whole has stake, especially in something that justifies government regulation. In ruling number 1, we found and held that, quote, public interest tilts in favor of allowing the constitutional process to proceed unhindered, end of quote. To therefore understand how public interest factors into this matter, it is necessary to examine the historical context of the office of the now Deputy President. Naturally, the starting point is the retired 1963 Constitution, which hereinafter will be referring to as the 1963 Constitution. Chapter 2 of the 1963 Constitution addressed the executive, with part 1 thereof focusing on the President and the Vice President. Section 4 of the 1963 Constitution established the office of the President as follows, I quote, there shall be a President of Kenya who shall be the head of state and Commander-in-Chief of the Armed Forces of the Republic, end of quote. Section 6 addressed a vacancy in the office of the President. And I may not go through all that, but it's in the ruling, you'll find it. Section 15 of the 1963 Constitution dealt with the office of the Vice President. This one I will read. Section 15, subsection 1, read as follows, I quote, there shall be a Vice President of Kenya who shall be appointed by the President. Subsection 2, the President shall appoint the Vice President from among the ministers who are elected members of National Assembly, provided that no appointment to the office of Vice President shall be made at any time when the functions of the office of President are being exercised by any person other than the President. Subsection 3, the Vice President shall be the principal assistant of the President in the discharge of his functions. We have emphasized that provision. Subsection 4, the Vice President shall not enter upon the duties of his office unless he has taken and subscribed the oath of allegiance and such oath for the due execution of his office as may be prescribed by Parliament. 5, during his tenure of office, the Vice President shall not hold any office of profit other than those of Vice President, Minister, and the Member of National Assembly. Subsection 6, the office of the Vice President shall become vacant, A, if the President so directs, B, if the holder of the office ceases to be an elected member of the National Assembly otherwise than by reason of the dissolution of Parliament, or C, upon the election of a person to the office of President. It follows that under the 1963 Constitution, the Vice President served solely as the principal assistant to the President in the discharge of the presidential functions. The Vice President had no other duties and could be dismissed by the President at will. After a lengthy and others 20-year pursuit for constitutional reforms, Kenyans ultimately adopted a new constitution in August 2010, which we'll be referring to as 2010 Constitution just to distinguish it with the 1963 Constitution. The 2010 Constitution has been widely praised as transformative, particularly for its fundamental restructuring of the country's constitutional and governance framework. The 2010 Constitution establishes the executive in chapter number 9. Article 131 outlines the authority of the President, while Article 132 details the functions of the President. Article 147 provides for the functions of the Deputy President as follows. The Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. 2, the Deputy President shall perform the functions conferred by this Constitution. We emphasize that. The Deputy President shall perform the functions conferred by this Constitution and any other functions of the President as the President may assign. Subject to Article 134, which deals with temporary incumbency, when the President is absent or is temporarily incapacitated, and during any other period that the President decides, the Deputy President shall act as the President. And Subarticle 4 says that the Deputy President shall not hold any other state or public office. It is therefore beyond any peradventure that the role of the President's principal assistant changed significantly in the 2010 Constitution compared to the position of the Vice President under the 1963 Constitution. Some of the notable changes include: 1, whereas the Vice President was solely the principal assistant of the President, the Deputy President is both the principal assistant of the President and also deputizes the President in execution of the President's functions. 2, the Deputy President performs specific functions conferred by the Constitution. 3, the Deputy President may perform any other functions of the President as the President may assign. 4, unlike the Vice President who was appointed by the President from among Cabinet Ministers who are elected members of the National Assembly, the Deputy President under the 2010 Constitution is elected together with the President and holds no other public office. The above changes were not without reason. In the book, The Constitution of Kenya, commentary by Louis and P.L. Lumumba, this is the second edition, Strathmore University Press, they are 2019 at page 453. The two eminent authors had this to say, and I quote, "With the other arms of government considerably weakened, the executive personified in the president exercised unchecked powers. Indeed, during the constitutional review process, the CKRC noted that the powers granted by the Constitution and the ordinary laws to the elected president seemed to share characteristics with those of the colonial governor. It then resolved during the constitutional making process to divest some powers from the president with the aim of avoiding an imperial president." End of quote. The above cannot be far from the truth. In the pre-2010 constitutional era, the president held immense powers, including the ability to appoint and dismiss the vice president at will, and the discretion to assign or to withhold duties for the vice president. Consequently, the vice president served entirely at the president's mercy. That was the framework that the 2010 Constitution sought to transform. Under the 2010 Constitution, the office of the Deputy President has been fundamentally redefined. It is now safeguarded from arbitrary and capricious actions by the President. Article 172 grants the Deputy President specific constitutional functions in addition to any duties the President may assign. This provision was intended to address the previous situation in which a President could, for any reason, choose not to assign any duties to the Deputy President, effectively sidelining them. Thanks to the 2010 Constitution, even if the President does not assign any additional duties, the Deputy President still has specific constitutionally mandated functions to perform. In this way, the Deputy President is no longer at the mercy and the discretion of the President. Under the current constitutional framework, when the office of the Deputy President becomes vacant, two outcomes flow. First, any functions that were assigned to the Deputy President by the President automatically reverts to the President. Second, the functions expressly conferred upon the Deputy President by the Constitution do not revert to the President and cannot be performed by anyone else. This is a departure from the 1963 Constitution, under which the President could appoint a minister to act as Vice President in the Vice President's absence. The 2010 Constitution includes no such provision. Therefore, if the office of the Deputy President is vacant, the specific constitutional functions assigned to that office remain unfulfilled. For clarity, not even the Speaker of the National Assembly may discharge the functions vested in the Deputy President under Articles 147, Sub-Article 2 of the Constitution. In light of the above, we are convinced and hereby find that the current constitutional framework does not envision any scenario in which the office of the Deputy President will remain vacant, except during the brief period required to fill such a vacancy. Another equally important provision that has credence to the above position, that the office of the Deputy President cannot be left vacant, is Article 146(3) of the 2010 Constitution. However, before we interrogate the said provision, suffice to note that Article 150, Sub-Article 2 of the Constitution, which is on the removal of the Deputy President, has it that the provisions of Articles 144 and 145 relating to the removal of the President shall apply with the necessary modifications to the removal of the Deputy President. Returning back to Article 146, which article deals with the vacancy in the office of the President, Sub-Articles 1, 2, and 3 of that article provide as follows. This one I'll read. Sub-Article 1, the office of President, read Deputy President, shall become vacant if the holder of the office dies, B, resigns, in writing address to the Speaker of the National Assembly, or otherwise ceases to hold office under Article 144, which deals with removal of President on grounds of incapacity, or Article 145, which deals with removal of President by impeachment, or under any other provision of the Constitution. Sub-Article 2, when a vacancy occurs in the office of President or Deputy, 1, the Deputy President shall assume office as a President for the remainder of the term. 2, if the office of the Deputy President is vacant or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of President shall be held within 60 days after the vacancy arose in the office of President. Sub-Article 3, a person who assumes the office of President under Clause 2A or following an election required by Clause 2B shall, unless otherwise removed from office under this Constitution, hold office until a newly elected President is sworn in following the next regularly scheduled election under Article 136, Sub-Article 2A. End of Sub-Article 3. Therefore, to us, a holistic reading of Article 146 alongside Article 152 of the 2010 Constitution, and in relation to the filling of a vacancy in the office of the Deputy President in this matter, yields the meaning that the person who assumes the office after the impeachment of the Deputy President shall, unless otherwise lawfully removed from this office, hold that office until further orders of this court or until the current term of the President ends, whichever comes first. The foregoing demonstrates that the structure of the Constitution, which reflects the popular will of Kenyan citizens, envisions a scenario in which the office of the Deputy President will always be filled except during the brief period of required to fill the vacancy as already stated above. Based on the foregoing, we now turn to the nature of the conservatory orders in this matter. It is widely accepted that the purpose of conservatory orders is to preserve the status quo pending further orders of this court. The Supreme Court in Gachagua, Peter Munya, and Dixon Mwenda Idhinja and 2 others say as much. In this case, maintaining the status quo would mean, 1, that the first petitioner remains impeached under Article 145, sub-Article 7, which affirms the finality of the impeachment process with the following provision, I quote, if at least 2/3 of all members of Senate vote to uphold an impeachment charge, the Deputy President shall cease to hold office, end of quote. 2, additionally, the prevailing status quo will mean that the Deputy President nominee, Professor Abraham Kithure Kindiki, does not assume office. With such an approach, while such an approach may seem fair, reasonable, and balanced, and one which this court will ordinarily be inclined to adopt, the unique nature of the Deputy President role under the 2010 Constitution suggests a different course. Allowing these orders to stand will leave the office of the Deputy President vacant. The problem, however, is that no other person is authorized to carry out the constitutional functions specifically assigned to the Deputy President under Article 147, sub-Article 2, once those assigned by the President revert to the President in the absence of an office holder. The result would be a de facto suspension of Article 147(2) of the Constitution, an outcome that no court should knowingly permit. For clarity, this court firmly holds that no court should issue orders that have the effect of suspending the operation of any provision of the Constitution, such an outcome is clearly not envisioned by the document itself. The Constitution was not handed to Kenyans on a silver platter. No, it was achieved through great struggle and sacrifice. Therefore, it is the duty of the court to uphold its provisions as intended by the framers and as demanded by the people of Kenya. Furthermore, Article 259 of the Constitution mandates that the document must be interpreted as always speaking. This means the Constitution is a living document designed to address contemporary challenges and to be applied consistently and continuously without interruption. Suspending any provision of the Constitution, even temporarily, would undermine this principle by creating gaps in its operation and disrupting the intended balance of governance. The Constitution is structured to ensure that all its provisions are effective and operative at all times. If any provision, such as Article 147, Sub-Article 2, is rendered dormant by a judicial order, it risks setting a precedent where parts of the Constitution could be selectively switched off, effectively weakening the Constitution's authority and the protections it affords. Additionally, we are mindful that courts are guided by the principle of constitutional supremacy, which requires that all judicial decisions align with the Constitution's objective and upholds its integrity. Issuing an order that suspends a constitutional provision would directly contravene this principle, effectively placing judicial discretion above the supreme law of the land. This will be inconsistent with the spirit of judicial restraint and the court's role as a protector and not a modifier of the Constitution. For these reasons, we take the position that the Constitution must remain fully operational at all times, and no court order should have the effect of rendering any part of it inoperative or dormant. The court's responsibility is to interpret and apply the Constitution as a cohesive functional document that serves the people's enduring will and protects the structure of governance as established. Drawing from the above, we hereby find and hold that public interest in this matter favors giving way to the Constitution, which in any event is the will of the people. That is also the dictate under Article 3 of the Constitution, where every person has an obligation to respect, uphold, and defend the Constitution. We choose to abide by that calling. As such, public interest demands that the office of the Deputy President should not remain vacant. Whether the consolidated petitions will be rendered nugatory in the absence of any orders. As we stated in ruling number 1, because the consolidated petitions challenge the entire impeachment process, the fundamental issues at stake remain live, even though the parliamentary proceedings have been completed. Furthermore, as previously noted, should any of these petitions succeed, this court will have no shortage of effective remedies to address the situation. The next issue is whether the applicants will be prejudiced if the orders are not granted. Regarding whether the applicants will suffer any harm if the conservatory orders are not granted, we find that no individual can suffer loss or damage when the Constitution is permitted to operate as intended. Allowing the constitutional process to unfold does not in itself result in detriment, as it upholds the rule of law and respects the framework agreed upon the people. The applicants also urge the court to grant the conservatory orders, expressing concern that the respondents have a history of disobeying court orders, and that once the office of the Deputy President is filled, it will be impossible to remove the appointee, even if the petitions were successful. However, this court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience of court orders. Moreover, the Honorable Attorney General, through Senior Learned Counsel Professor Getu Mugai, has given an undertaking to comply fully with any orders which will be issued by this court in this matter. As such, we find that the applicants do not stand to suffer any prejudice in the event the conservatory orders are not granted.
Disposition. As we conclude, we reiterate that this matter holds significant public interest, and we remain committed to an expeditious examination of the petitions. Therefore, we will further provide directions within this ruling. Consequently, the following orders are hereby issued. 1. The applications for conservatory orders are hereby disallowed. 2. The conservatory orders issued on 18th of October 2024 in Keregoya High Court E015/2024 are hereby discharged and or set aside. Costs of these applications shall be incurred. We grant leave for appeal, typed proceedings and certified copies of this ruling to be availed to parties at cost or as it may be. We will mention this matter on 7th of November 2024 at 2 p.m. in the open court. This ruling shall forthwith be uploaded in the court tracking system. That is the ruling of the court.
My Lord, do we want to take this opportunity to thank your lordships for the time that you have taken and the judiciousness with which you have expedited the applications. And I also want to thank my colleagues from the respondent side and from the applicant side for the maturity with which this matter has been handled. We are most grateful, my Lord.
Thank you. My Lord, my name is Judicial for the Deputy President, and I wish to make an application. The application I wish to make is called the Matthew Pepper Injunction. Matthew Pepper International, quite a famous case. In the common law, it's called the Erin Ford Injunction. My Lord, the Matthew Pepper Injunction operates on quite a simple premise, the premise of human vulnerability. In the case of Erin Ford, where that injunction originates, Justice Megal, after dismissing an application for injunction like you have now, found still that there could be the slightest chance that he was wrong. Here, there could be the slightest chance that you're wrong. Last week, this court gave the Deputy President leave to appeal. We thank the court for that generosity. The Deputy President has appealed. He also has pending before the Court of Appeal an application for stay of these proceedings. And that application comes up on the 6th of November 2024. My Lord, operating on the premise of human vulnerability, the foundation of the Erin Ford or Matthew Pepper injunction, we request you to recognize that you could be wrong. And if you're wrong, then the pending proceedings before the Court of Appeal would be rendered nugatory. To avoid that possibility, the possibility that the Deputy President's right to appeal, which you recognized and affirmed and upheld by giving him leave to appeal, even where he needed none, we ask you to issue a Matthew Pepper injunction. We do not seek an indefinite injunction. We seek an injunction until 6th of November 2024, when we are next before the Court of Appeal. Thank you, my Lord.
My Lord, we also have a moment by the chair. Yeah. My Lords, I want to associate myself with the submissions made by my learned friend, and also state that I have listened keenly to the ruling that has been delivered by this honorable court. While we largely disagree with it and we have a right of appeal, Your Lordship, it is imperative for us to know or to assess how that office of the Deputy President will be filled. This court has affirmed its commitment to observe the rule of law and protect the Constitution as decreed under Article 3 of the Constitution. It follows, therefore, Your Lordship, my ladies, that the filling of that vacancy must flow or must follow the Constitution. And as such, Your Lordship, and as much as I have not heard the court address that very pertinent issue, it is my submission, Your Lordship, that I raise under Rule 23. Beg your pardon. Rule 23 and Rule 24 of the Mutunga Rules. And I make an application, Your Lordship, that pending the determination of this application, done under Rule 24, that this Honorable Court does issue conservatory orders suspending the swearing in of Professor Kithure Kindiki on the following grounds. Your Lordship, Article 10 of this Constitution, of the Constitution, bids this Honorable Court to observe the rule of law. It further calls upon this Honorable Court to commit itself to ensure that there is good governance, there is accountability and transparency in the manner in which matters are done or functions are executed.
My Lord, with your kind permission,
It's an application.
Mr. General has referred to an application for which we're seeking some orders pending, but we haven't seen any application in that regard.
Yes, Your Lordship, if Mr. Kamoso was keen to read the rules, the Mutunga rules allows me to move you informally. And subsequent to me making an application informally, the court is called upon to reduce the same into a formal application. And that, Your Lordship, I want to draw his attention to Rule 24, Sub-Rule 1. An application under Rule 23 may be made by way of notice of motion or by an informal document. Your Lordship, permit me to proceed with the grounds of my application. It is clear, Lordship, that the court...
If I may, I respect my Yes, I respect Mr. Njiru. He's referring to an application that is non-existent. Either is referring to E554. So I'm going to sit down. E554 of 2024, which is before the Court of Appeal, if you are referring to that application. But my Lord, if Malani Friends is referring to the exercise of this court of a epistolary jurisdiction, then he should say so. But he cannot refer to the exercise of that jurisdiction, my Lord, when this court is functioned as officer. You have rendered yourself on the question of the application. And therefore, they cannot urge an application unless they say, my Lord, number one, is either served on us, or two, my Lord, because there's already an application for stay under Section 5(2)B of the Appellate Petitions Act before the Court of Appeal that is live and that has a date. This court would not have jurisdiction to entertain any other application for stay. They tried making an application for the Court of Appeal this morning using the same issues, my Lord, and the Court of Appeal rejected the application. They were told to serve everyone else. So, my Lord, for my friend to come here and to seek to apply for stay again, having a second bite at the cherry, is dishonest, my Lord. It's dishonest. That before the Court of Appeal.
May I suggest, Professor General,
That could be your response to the application which will be made by Degwa.
Yes, if there's an application here.
Thank you, Your Lordship. Your Lordship, permit me to move on with my application, and I ask Professor Ojenda to have a look at the rules that I have just referred to. That, Your Lordship, you be kind enough to interrogate the circumstances under which that office shall be filled. Your Lordship, it is on record, and I invite the court to take judicial notice, that there is a clear non-existence of a crucial state organ that is supposed to oversee the processes of filling of that office in the name of the Independent Electoral and Boundary Commission. Your Lordship, the Independent and Boundary Commission is created under Article 88 of the Constitution, and the functions are created therein. One of the functions, my lady, is to maintain a voters register, is to register voters. Under Article 99, your lordship, of the Constitution, as read together with Article 137, creates the qualifications upon which the president or the deputy president must attain if one is to hold office. My ladies, my lord, it is clear that the functions created under Article 99 of the Constitution can only be executed and or implemented by the Independent Electoral and Boundary Commission. It goes without saying, my ladies, my lords, that a deputy president designated or nominated must attain those qualifications. That is to mean, my ladies, my lord, that there must be an organ that will give a clean bill of health to say or to suggest that Professor Kithure Kindiki attains these qualifications. My lords, my ladies, I refer to the memorandum that was sent to the Speaker of the National Assembly by the President of the Republic of Kenya, dated the 18th of October 2024. In that memorandum, your lordship, the President drew the attention of the Speaker to the clearance of the designated candidate by the IBC. And this is what the President had to say. Your lordship, the President indicated that he has had confirmation that Professor Kithure Kindiki meets and attains the qualifications created under Article 99 as read together with Article 113 of the Constitution. My ladies, my lords, when the President of the Republic referred to the IEBC, and I call upon the court to take judicial notice of that document, it was a presumption that that confirmation was done by the Electoral and Boundary Commission as created by the Constitution. My ladies, my lords, it's my humble appeal that this honorable court does fight in my favor to issue the conservatory order on the basis that there is no clearance that has been issued by the IBC. We all know, my ladies, my lords.
My lord, may I kindly seek your guidance? When Mr. Giro started off, we thought it would be a simple and a straightforward application. But now, seeing the trajectory it has taken, he has raised a number of issues for which we would require them reduced in a particular format so that we can seek instructions from our client. So we're seeking that we get a formal thing that will enable us to seek instructions.
Remind me your name.
Dr. Kamodo for the 10th respondent.
Your Lordship, I am making an application on the basis of the law. Your Lordship, if it is not crucial for us to have an IBC to confirm whether Professor Kithure Kindiki is a registered voter, that will mean, Your Lordship, that a person can go to Mathare Hospital and designate a person to become a deputy president. The qualifications created by the Constitution have a mechanism of being established, Your Lordship. And the process of establishing those qualifications, Your Lordship, is set down and out in law. Your Lordship.
Mr. Njiro, my understanding, when you first asked for this conservative order under Madu paper,
Yes, sir.
it
That
was
is his application.
Yeah.
I have on a different application. I moved an article.
Because my understanding is that if you want the court to give conservatory orders immediately after rendering a ruling or a judgment, that application can be verbal but also very short, because the court is already aware, has already expressed itself.
That's correct.
So that kind of application cannot be the beginning of another big
Your Lordship,
application.
I am well guided.
So I think for the purposes of the discretion of the
Yes,
bench,
Lordship.
for the purposes of the discretion of the bench,
Yes,
I
Lordship.
think Mr. Ochieng's application is what we should be considered. Your application evidently requires to be formal.
Your Lordship, I am well guided by the court, but the court also needs to perhaps appreciate the import of Rule 24. That due to the vulnerability of the rights and the vulnerability of the infringement and violation of the Constitution, I can appear before you.
Rights cannot be vulnerable. Individuals are.
May I have
Not
my
right.
time and then you have your response, Professor? Your Lordship, this application is premised again on Article 3. The call upon every person to protect the Constitution. And as I pen off, it is all clear to us that nobody can deny, not this court, not myself, nobody can bury his head under the sand, that there is no IBC. If Kithure Kindiki is to be sworn in tomorrow, what will be the import of swearing in a person who has not been verified and approved by the organ that is supposed to do so? Finally, Your Lordship, can this court fold its hands and watch and midwife and babysit a violation of the Constitution? What is the role of the court when it comes to the issue of Article 3 of the Constitution and the question of the sovereignty of the people? Your Lordship, I beg that you hear us. I beg that you grant the conservatory order staying the swearing in of Professor Kithure Kindiki on the basis that he has not qualified to hold that office. Secondly, on the basis that his purported qualification has not been verified by the body that is mandated to do so. In the absence of that, Your Lordship, you'll be inviting us to say that even an insane person can become deputy president, a bankrupt person can become deputy president.
Objection.
I rest my case.
My Lord, let me respond to.
So that Professor Ojenda and every other counsel who is seated, please sit down. We have two applications, and this is not going to be a start of another court process. It's not going to be a start of another court process. The applications which have been made are discretional. So I'll only allow one response, and then we'll render a ruling. Only one response.
Yep, my Lord, if I may respond, my Lord. My Lord, you made a ruling.
Okay. Okay, let me hear two people from this side and two people.
And two. You're one person.
Dr. Kamilwa, please say what you want to say and be mindful of time, please.
Yeah, I want to take my time. Justice Eric Obola, Justice Andrew Rema, and then Justice Frida Gandhi. I've listened to what you have said very carefully. And from my point of view, one who is interested in developing the goodness of the country, you have done, you have developed. But there is one thing I would like to point out to you very first. That we are operating in very dangerous water. With strong current. And this is an area where we have to call for wisdom We have called for deeper understanding of human nature and for deeper understanding of the society in which we live in Kenya. And what I'm saying to you is reflected in my broad reading of the authorities in cases in the United States of America. If I may say so with respect, perhaps more than anything else, when I was engaged to get involved in this case, I ordered for a book from India straight about the electoral report on impeachment. And I've taken the trouble to read them day and night. And one thing that has emerged from all these authorities when I was reading them very carefully is that the court in the United States have continued to think very carefully how will these judgments be received by the people, by the consumers. How will it be received? Is it a judgment that will continue to promote stability in the country? Is it a judgment that will continue to promote the rule of law? Is it a judgment or ruling will continue to promote stability in the country? And it's here that I'm inviting you very respectfully that you consider the able remarks of my learned friend, Mr. that we should not, as my friend mentioned,
only it's one-sided.
We should not ignore what they are saying like this.
But it looks good. They're finished enough.
We don't want to move out of this courtroom.
Then I'm going to date at a
And then all of a sudden I told that the protest now in second. I'm not trying to
just hold on.
all that I'm saying to you.
Sorry, my lords. The utterances by the Honorable Dr. Hamino, Counsel, are. I'm giving you the title, sir.
No, what I'm saying, let me say what I'm.
Unfortunately, they're insightful. They are trying to preempt matters that are not before this court. We do not know, and we cannot speculate that anyone is going to be happy or unhappy about it. The sword of justice cuts both ways. There are those who are going to be happy, there are those who are going to be unhappy. That is how life is, but you cannot incite by saying from here, we will have protests, we will have what? We do not know of that. And unfortunately, my lords, I ask you to kindly restrain him from taking that route.
With your kind permission, Your Honor. Oh, sorry.
We have rendered ourselves in this matter. We have rendered ourselves in this matter, and we are not going to open this matter for a further court proceeding. There are two applications before the court, one by Dedlo Chieng and one by Ndegwa. After Dr. Kamuna has spoken, we'll allow two people to respond, and then we'll make a ruling.
Thank you.
I know that was also you indicated we have two people, and I was prepared kindly to make an application.
Continue, Dr. Kamuna.
I'm actually it's only one sentence. When you read the book, I have referred to authorities in America. The judges have made a finding along this line. Yes, this is the people. So and so is guilty. But we shall not go ahead. We shall be held. So that's all I'm saying to you. You have come up with a very, if I may say so, a ruling full of students, and particularly my Lord Gachagua has come up with something which I had not thought of very much at all. But all that I'm saying to you, that you agree, but you still have the discretion to say that, look, we are not, these are our findings. but still we are going ahead to give conservatory orders for so many days or so many weeks. So you still have that discretion for the sake of the country. Thank you.
My Lord, may I kindly, my name is Sam Meberi. I appear for the 9th petitioner in the second cohort. My Lord, I stand to make an application for stay of the orders that have been issued this afternoon relating to the application that was before you, and having keenly listened and internalized the import of that ruling or order, Lord, we wish to move the court, much as we have that opportunity by way of the orders that were given, that we were given right to appeal, that pending the appeal, pending the lodging of the appeal, my Lord and my Lady, you allow us that opportunity of stay so that we can ventilate our issues before the appellate court. My Lord, what informs this application is that there is an apparent risk by the fill-up of the position of the Deputy President, and in our petition we had named the Professor Kigura Kindiki as a party in the petition that we had filed for the 9th petitioners. So that, my Lord, having analyzed and internalized that, we feel that the petition, in the fullness of time when the court is going to process it, we will be dealing with an issue that perhaps will compromise the rights of the 9th petitioner who has moved the court. And my Lord, the other issue is that there is a period within which the respondents, if they have to move, they have to fill out that position of the Deputy President. So that, my Lord, there is no any prejudice that will be occasioned to the second respondent if the orders of stay gets issued, because by close of business today, my Lord, we are going to lodge the notice, and that notice by itself acts as an appeal, and in the fullness of time, we shall be processing the application before the appellate court for appropriate orders to issue. My Lord, I therefore associate myself with my colleagues on the application for stay so that we don't have the proceedings before you in the fullness of time when we come to canvass the petition to be rendered nugatory or academic. My Lord, you have the discretion, and we ask and beseech you to exercise that discretion in the favor of the 9th petition. Thank you, my Lord.
My Lord, I would like to make an application under Article 1.1 directly. And my lady. My lords and my lady, we are thankful for your ruling today and the lengthy explanations and court case that has gone into it. Unfortunately, my lords and my lady, it seems that some people are being favored over us, and in this matter, it is the state or advocates. We are here acting in person, and we are entitled to the same equal protection of the law. We are here trying to defend the Constitution and our constitutional rights. I am being discriminated against as a woman, as a person with disabilities, and as a youth, my lords and my lady. We filed our application on the 8th of October 2024, and we thought that we would be enjoined as interested parties to participate in Tuesday's proceedings, but we were not. So we did not have the time to ventilate our issues properly. My lords and my lady, we are asking you to stay your orders for 7 days, as you have told us to come back on the 7th of November, so at least we get a fair chance, a fair fighting chance as a sovereign to also ventilate our issues properly. The state cannot override us, and advocates cannot override us, my lords and my lady. This is a court for equality, and we are asking for equality. My lords and my lady, we also appreciate that the regardless side has asked for 7 days to appeal. Kindly consider us in, because there is no point in justice. It will be granted to some petitioners, and others will just be thrown under the bus and into the darkness. Thank you.
Lord, if I may respond.
Can you just clarify? Your application says dated the 8th of October?
8th of October, 2024. is petition E541 of 2024, who was seeking stay orders to stay the proceedings in the National Assembly based on Article 32(1), freedom of conscience, and Article 33, freedom of expression.
Maybe with your kind permission.
Let me clarify. Is that the matter in which you are dealing with Dr. Bosso?
Yes, my lord.
Yes. Now, if you have been following the directions of this court keenly, we have been issuing various orders on consolidation. And I can assure you, I did that. And you and Dr. Bosso are petitioners in one of the cohorts. I think it's cohort number 1. Yes, it's cohort number 1. You are petitioners in cohort number 1. And we directed everybody to get into the CTS system. And whoever has a problem to get in touch with the deputy registrar. So it is not right, Ms. Wanjiru, to claim that you have not been enjoined in this proceedings. You have been enjoined, you are a party, and that is why we allow Dr. Bosso to address the court, even yourself.
Yeah,
so you are a party. You are a party. That one I can assure you.
My lords, we were not entitled to the right of enjoinder, and we had points that we wanted to defend against the respondent's side. So we're just finding it very difficult that due process is not being followed in our instance, as we applied even before both parties on the 8th of October 2024. They came to court on the 18th, 10 days after us, and they have still been granted audience before us, and we were told we're going to be in cohort 1, and then cohort 1, this application has already overtaken cohort 1. We're now being told to come next week after the swearing in would have been gone through and after numerous rights would have been violated that we have raised.
I think, Ms. Wanjiru, what you just need to do is just get into the CTS, get all the directions. There's every direction. There's a reason why we came up with cohort 1 application petitions and cohort 2 applications.
Yes, my lord.
So I think we may not wish to respond on whether you are discriminated or not, but we are so sure you are not discriminated because there are proper directions in respect of every cohort and every matter before us. Kindly take time to go through the city.
My lord, I offer to assist.
Thank you. This court had made directions on this issue. Yeah. We said there are only 2 applications before this court right now, and those are 2 applications which will be responded to. We have applications, we are finished with this side.
You have not spoken on behalf of the second petitioner.
My lord, that would like an opportunity to respond to both applications that are being brought today.
Maybe I can say one thing, just on behalf of the second petitioner. My name is Kimoto Justiciability, Makazi. Yes, there's Kimoto of the company.
You're joking.
We welcome the ruling. However, there's some bits that we feel aggrieved and we wish to appeal. And therefore, as we do the notice of appeal, we're praying that we are in support of the issue for injunction, no the issue for stay, which the court may say it's a legislative order, but we are saying pending the time we do the appeal, at least the status quo be maintained. And also we wish to say that there was an issue that the court of appeal today dismissed an application for stay. That is not true. We were told to serve, but we were not all served, and that's the reason why we were given another date. So therefore, we are in support of these 2 applications that have been made today.
Let's also. Yeah. Mr. Dr. Bosso.
Yes.
Please sit down. Please sit down.
My lord, this court.
Please sit down. Please sit down.
Will I be given a chance to speak?
Please sit down.
Give it to Wanjiku. Let her talk.
Yes, my lord. As a young woman, I'm under 35, my lord. I'm actually 35. I'm a youth and I have a disability. And we're the owners, I think, on the platform that check that we have a disability, my lords and my lady. Our constitution, Article 1.1, has to count for something. Because it was intended for us to come to court directly.
Please respond to the application. Support make the application.
Yes, my lord, I'm in support of the application. Most obliged.
My lord, finally. My lord, in response to the two applications.
My lord, there are three, not two. Actually, four.
But they are saying the same thing. They're saying what to. There are two.
Yes, my lord, in response to the application by my learned friend, Mr. Judicial, future senior counsel, and my learned friend, Mr. Wanjiru, I wish to say that follows. My lord, number one, the Matthew paper order sought by my learned friend fall on the basis of the following principles. Number one, my lord, there is already an appeal that has been filed in the Court of Appeal, and an application for stay under Rule 5 to be filed, being application number 554 of 2024. The Court of Appeal is therefore seized of this matter, already seized of this matter. In those circumstances, my lord, a party can only apply for stay in the Court of Appeal. That's point number one. My lord, point number two, ordinarily, when a court delivers a ruling in a matter, the court becomes functus officio in respect of that particular matter. My lord, that matter therefore, or the applications made are therefore res judicata in the sense that a determination has been made. And this court cannot go back and approbate and reprobate at the same time. You cannot deny an order and then purport to issue the order again. Point number three, my lord. My lord, rules 23 and 24 of the Mutunga rules as presented before you, together with an application by my learned friend on substantive issues touching on actions that may be undertaken subsequent to this, including, my lord, the qualifications of the Deputy President nominee, Kithure Kindiki, can only be brought to this court, my lord, through one, either a new petition and a new application, or two, my lord, through an application for review. The only avenue that Mr. Ndego can bring all the issues that he has spoken to this afternoon are application through review. No application for review or setting aside has to be filed before this court by Mr. Ndego. And therefore it is inconceivable, my lord, that this court would entertain the application brought on several grounds, my lord, including grounds challenging the suitability or otherwise of the Deputy President nominee. My lord, lastly, and because my learned friend will submit further, once a court has delivered a ruling, my lord, the justice of the cause is that consequential processes can be undertaken given that there are no orders in place. And that is not for the court to be part of or to control. That is for other parties, probably not before this court, my lord. My lord, what you have done is dismissed the application of Conservatory. So that's a negative order. If the court cannot be invited to review or to stay a negative order that has dismissed an application. And the negative order again goes to the application by Kimodo and Company Advocates from Kerugoya, who has also sought to stay your orders. Yet, all that application had, my lord, was for the former Deputy President to apologize, former underlined, to apologize to NIS. Surely, Kimodo, you can do better. My lord, I will invite my friend.
You are protected, you are protected.
Right? Mr. Kimodo and company.
Yes, my lord, my name is Mudhomi Fiankolu for the second interested party. I have listened very keenly to the two applications.
Let's see what to say.
And the issues for you to weigh in your mind are as follows. One, if the outcome they seek through these two applications was declined by the Court of Appeal, not yesterday, but today morning, can this court, being a court lower than the Court of Appeal, on the very same day be seized of an application that results in the very outcome?
May I kindly bring it to your attention that counsel has a duty to this court to speak the truth. Being an officer of this court, being a doctor and a teacher of the law, he understands the duty that he has towards you and towards the law and the fidelity to the law. It is not true that an application was dismissed. It is true that parties were told to serve. So let's submit on the premises of facts and not the premises of presumptions and the intentions to mislead.
It was declined. It was declined. Application for stay was declined.
My lord, I think it's an issue of semantics. I come from a community that is not an expert in the English language, but whatever you call it, the point is this. The effect of you granting either of the two applications would be to contradict a decision by the Court of Appeal today morning, not to grant similar applications. Yeah. That cannot be denied in good faith.
We are objecting to this. They are misleading. I was before the Court of Appeal.
Another application was made.
My lord, the Court of Appeal is a court of record. I don't want to belabor this point. Let me move to my next point. The Court of Appeal is a court of record, and I'm sure the court has access to that record. Two, my lord, it is not like Kindiki was nominated yesterday or the day before yesterday. He was nominated several days ago. If the applications now being made were made in good faith, they should have made a formal application several days ago, which would have been on record, which would have had the opportunity to respond to. You are now being invited by submissions from the bar without a formal application to grant some relief, supposedly on the ground that Kindiki is unsuitable. That cannot be proper, my lord, especially when the nomination of Kindiki wasn't made yesterday or last night. They had notice for several days. If they have any issues with the suitability, they would have filed an application on that regard or even amended the applications we just determined, and they were granted that leave, and they didn't amend them. So surely it's an ambush for my colleagues now to stand up and start telling you Kindiki this, Kindiki that, and therefore stay, and therefore Madhu paper this and that. Two. Number three, my lord, what you're being asked to do is to flip-flop or to behave like a pendulum. My lord, a pendulum moves from this end to the other end, but it never leaves the two extremes, so there is what I usually call motion without movement. The court has already read a ruling to us saying that it cannot issue a conservatory order that would have the effect of suspending any provision of the Constitution. You're being invited right now to do exactly what you have just told us cannot be done, and you're told the reason you should do that is because you're human and there is a possibility you're in error. Of course, there is a possibility, my lords, you're in error, but there is a court that exists to correct errors made by this court. You're being asked to embarrass yourself to say just a few minutes ago that the conservatory order should not have issued in the first place, and then you're being invited to issue an order that would have the contrary effect. I think they are setting up the court for embarrassment. My lord, there is a reason, there is a law which we all know because both the people in the bench and the bar are lawyers. And it is common ground that no appeal operates automatically as a stay of any decision made by any court. The reason that rule exists, my lord, is so that whoever is desirous of an appeal can move the appropriate court, which they have done, and persuade that appropriate court to issue that stay. So they are telling you, because there is a possibility you might be in error, therefore automatically, but the rule, if I understand it, is that no appeal, let alone an intention to appeal, can issue automatically. Lastly, my lord, you have been told about a Madhu paper, a junction. I thought we were talking about conservatory orders, my lord, because Munya told us injunctions are remedies in the realm of private law. They exist to protect personal private interests. And conservatory orders, which you just said cannot issue in the circumstances of this case, are the remedies available in public law for the ordered functioning of public agencies. And because, my lord, I said this court has jurisdiction, if eventually you find that the Honorable Rigathi Gachagua was not lawfully impeached, this court has still confirmed it has a remedy. It can undo the entire process. Let us not detain you here, back and forth, flip-flopping, behaving like a bedlam. It is holding the court at ransom, in my view.
Thank you.
My lord, if I use only 2 minutes,
after that, you will respond after Peter.
Yeah. My lord, I'll just take 2 minutes to mention something which will be in addition to our case. My lord, Article 10 of the Constitution outlines the doctrine of rule of law. My lord, my lady, the doctrine of rule of law anticipates that at some point controversies in the society, especially legal controversies or controversies related to the interpretation of the Constitution, will be determined by judges. And concomitant to that is the doctrine of finality of your decisions. And more importantly, the public policy in terms of consistency in judicial decision making. So, my lord, my lady, once you've made a decision, the expectation of the public is that you will stand by that decision, unless there are exceptional reasons for you to depart from that decision. Especially immediately after you've rendered your decision, it will undermine that doctrine of finality of judicial decision making. If you immediately depart from the decision without exceptional reasons, they have not put on record exceptional decisions to warrant that immediate departure, and the public expects that your decision will be enforced. Secondly, the doctrine of rule of law again operates in a complete way. John Locke in 1689 developed a concept in his treatise of government known as the concept of inalienable right, which informs our Constitution. And one can mention here that judges have a right to be wrong. They say you have a right to be wrong. We have listened to your decision, and we believe that
you are not wrong.
The reason why conservatory orders cannot be continue is a heavy public interest reason of the need for the vacancy, for there to be no vacancy in the office of deputy president. And the Constitution does not anticipate that. So in conclusion, the provisions of Article 164(3), based on the way the rule of law works to model the fabric of the society, they have the right to appeal. My lord, you have granted that right in your ruling. And from where we stand, we submit that they cannot, on this matter of immense public interest, where you've made a decision for them to seek, to make an application from the bar, to upset a decision which you have rightly pointed out is meant to fill a major constitutional gap in respect to vacancy. And lastly, the right to be heard. The right to be heard is very central. Mr. Ndegwa has made factual statements in this matter in his oral application. Again, given the immense nature of this matter in terms of public interest connotations, it is important that the respondents are given opportunity to specifically rebut the factual questions of law, the factual questions and some of the legal points that they are brought up. So in that case, if they really want to move this court, then we will submit that the proper way is to make a formal application so that we are hard on that question. Thank you.
Your Lordship, the IEBC, the second application was directed at us. Everyone seems to have said something except the IEBC. And I just want to make two small points. Number one, as it relates to the application by Mr. Ochieng Dati, my friend. First, Magu paper was pre-2010 constitution. That is important for the court. It was a commercial matter relating to restitution. So it was a remedy in private law, not in public law. Magu paper was pre-2010 constitution. It was a commercial matter, a restitution in private law. So this will not apply. The second issue, application by Mr. Ndegwa, Learned Counsel, I am looking forward to reading the decision of the court, because those were issues that we were on our feet for 30 minutes arguing about the role of IEBC and what needs to happen. So already the court has made a decision on that, and likely the answer will be in the ruling that the court has already read. Third one, and most importantly, I want to point to the court the case of Elliot Matindi and two others versus the President of the Republic and the PSC, E084 of 2023. It is the CAS matter. And it feels almost like deja vu that Ochieng Dati is here making this point. We lost that matter in the High Court. The court made a finding that the offices of CAS were not constitutional office. We were on our feet for a long time trying to urge the court to give us a Magu paper injunction. And the court said, if the issue related to constitutional compliance or constitutional infraction, as the court has already noted, that the position of the Constitution must remain operational from the decision of this court, then that injunction will not apply. The remedy is for the parties to apply to the Court of Appeal for an appeal or a review of that decision. So those three things can clarify those two issues for the court. We think these applications are not merited, and the court and the parties should put more effort in the fight for the application. Thank you.
My Lord, perhaps before senior speaks, maybe we get directions as to how many they are responding, because there was
all of us
on the side, and
all of us
we were restricted as the petitioners.
All of us.
The court would give directions as to that.
Let Mr. Moses speak.
Thank you, my Lord.
My Lord, but you have not given us directions as to how many of them should address you, considering that the petitioners were restricted.
We said two. Three of them have already spoken.
Okay. My Lord.
Mr. Moses, nothing stops you from saying that you adopt the position of your predecessor.
Exactly. That's correct.
Yes.
My Lord, I want to say that I associate myself with the sentiments by my colleagues, but I want to add, my Lord, that you have given a detailed and a very comprehensive analysis of your ruling. You've gone into graphic details, and you have addressed various issues and given a determination on the same. We are not before this court, my Lord, to litigate in installments. My learned colleague, Mr. Ndegwa, has all along been aware that Professor Kindiki was nominated. For him to just spring up now and start raising issues concerning Professor Kindiki is just but a mockery of the justice system. My Lord, you've made a determination. You have thanked us official. We will not want you to reopen these proceedings again. They have known the available avenues to them. Let them proceed on those avenues. I submit, my Lord.
Thank you very much. On only one point, which I actually objected to when it was being made, the point was that how would Kenyans receive the decision? I'm not so sure whether this is what these applications should be based on, because whichever way, there will be parties that will be aggrieved by the decision. There are many others that will be satisfied. Do not be misled that there would be protests, just the way I also cannot mislead you by saying there will be jubilation and celebration everywhere. The position remains, the court has rendered itself. In that decision, the court is thanked us, and therefore we have now to move on. Any party aggrieved knows what to do, which is either to appeal, apply for a review, variation, or whatever it is they have to apply for. If the processes that will take place after this would be contra the Constitution, every party knows what to do, and this court is still seized of the matter, and they will be coming over here for a pronunciation on what the constitutional rights are. Therefore, we should actually not be taking the route that the decision may be popular or unpopular. It's a decision of the court, and it cannot be challenged along those lines.
Thank you.
My Lord, honoring the court and my colleagues' time, this is my rejoinder in exactly 2 minutes. My Lord, Rule 32.2 of the Mutunga Rules allows us to make this application informally as we make it. Rule 32.2 of the Mutunga Rules allows us to make a Matthew paper application as we do. It says the application can be made informally immediately after delivery of the judgment. Rule 32.2 Mutunga Rules. My Lord, this President, the Attorney General, when on the other side, has many times sought a Matthew paper injunction. In the Finance Act litigation, where my friend Mr. Somane was present, Justice Majanja presiding, this court, in this rule, issued a Matthew paper injunction. My Lord, on the last point, my lovely friend Mr. Ojenda sounds familiar with the Matthew paper case. It's a Court of Appeal decision. I saw the first one, Bat versus Rent Tribunal, is one of the most cited cases on the question of stay. And in that case, the Court of Appeal said, my Lord, allow me to read, and then I'll sit down. There is no inconsistency in granting such an injunction, a Matthew paper injunction, after dismissing the motion. The purpose of the order is to prevent the Court of Appeal's decision from being rendered nugatory. Should that court reverse the High Court's decision? Respondents concede that you could be wrong. There's human infallibility. The purpose of the request we make is to respect that issue. What if you're wrong? And you allow the wrong person to come into the high office you've just established. My Lord, allow the request for 7 days. Thank you so much, my Lord. And my Lord, may I just clarify that our application is distinct. We do not seek stay, we seek an injunction. Thank you.
And I'm interested, in the event, my Lord, it's allowed, can we also move you again to remove it?
Orally, yeah.
No, my Lord, I think in view of Article 50, they also have a right to make that application. Your Lordship, allow me to draw your attention to Article 149 + 1. That London is not burning, and that a vacancy is contemplated, and actually a vacancy of 74 days, within which due process ought to be initiated to ensure that a rightful person fully qualified, fully known in law, fully appreciated by the law, takes over office. Therefore, this vacancy is a constitutional vacancy. Further to that, Your Lordship, permit me to address you that this is a new application and this application has not been determined. Further, allow me to indicate that I listened pensively to the three thematic issues that were raised by the court, and this is not one of them that was raised and resolved by the court. Finally, Your Lordship, we all have a duty to uphold the law and to defend the Constitution. On the 16th of October 1953, Fidel Castro had this to say in his defense, that history will absolve me. History will absolve the petitioners. That you have brought to your attention that you have the duty to protect the Constitution, that a person qualified should take over. I'll wait for the ruling. Finally, Mr. Somane has not addressed you on the qualification and the ability of a person to meet those qualifications under Article 99 and Article 97. He has not even told you that they are not applicable. If the court wants to say they are not applicable, history will absolve me. If the court wants to say that has no power to defend the Constitution, history will absolve me. If the court wants to pave way and mutilate this Constitution, history will absolve me. If the court wants to midwife an injustice, history will absolve me. I am most obliged.
My Lord, Subject for the ninth petition. Only two issues. I invite you to Article number 23 of the Constitution, which gives parties rights to come before you. Article 23 of the Constitution, which allows parties to come before you to seek for leaves. And in this instance, we are seeking an injunction by way of a stay, albeit temporarily, of the orders that this court has issued. And we are not seeking these orders in eternity. We are moving to go to the appellate court once we have the ruling. Number two, my Lord, I invite you to the application by the ninth petitioner, the notice of motion application dated 18th of October. Because there was an allegation that we have been sitting here and it's coming as news that Professor Gachagua has been nominated to take over the DP position. My Lord, that notice of motion application speaks to the application that we're making. That it was seeking for a conservatory order, and the court has rendered its decision. So we are inviting you kindly to exercise your discretion, so that we may have that application processed before the appellate court, if it is found of merit, so that we don't have to have it as an academic exercise. Thank you, Madam.
May it please the court. My name is Dr. Iboso, and my co-petitioner had made a similar application that you, the Honorable Court, be pleased to stay the order that it has given today. And the respondents have raised an issue that Professor Kindiki was nominated over a week ago, and that if we were raising this application in good faith, then we ought to have raised it earlier. I wish to refer the court to its directions, which made it clear that one, the only applications it was going to hear were the two applications that were before the court. And this was made despite protests that my co-petitioner and I have raised for the last 2 weeks, that we have applications that seek similar orders and they've not been heard. However, I also would wish to direct the court to its own directions, which directed that we file amended petitions because many of the petitions had been overtaken by time. And if you look at our petition as amended, we actually raise concern about the process of election of the deputy president designate in our amended petition, and so it is quite in substance and whatnot. Secondly, I'd like to point out that my co-petitioner pointed out that we have been feeling discriminated, and as she explained earlier, she's dyslexic, and sometimes she might rush her words, especially when she's tense. The feeling of discrimination that we've been having is that out of all the petitioners, we are the ones who have consistently for the last 2 weeks called on the court to refer to the applications that are before it, and that which touch on this, and we be given adequate time to ventilate them. Yesterday, I agree, we were given an opportunity to speak as interested parties, and after the respondents gave their case yesterday, I tried to catch the attention of the court, and I was ordered to sit down. I wasn't rising because I don't have a right of response. I know that. I was rising because I sought the discretion of the court, specifically because there are specific 4 issues that the respondents raised against the things I had raised. And in the decision of the court today, which I have listened to, one of the issues has actually turned on that. The fact that this court believes, which I believe is wrong, that it has jurisdiction to reverse the assumption of office of the deputy president. Of course, you've given a ruling and we respect it, and we wish to appeal that ruling. However, now we are asking the court, because both the respondents and us applicants agree that we have moved the Court of Appeal, and the Court of Appeal has given a mention date. So the court is aware of that, or at least that is not disputed. We are asking the court to stay its decision today, allow us to move the Court of Appeal appropriately so that it can give the necessary orders as relates to that, even if it means correcting what we believe to be the wrong finding of the court. The idea that this court is functus officio does not arise, because the rules of the civil procedure, I'm not sure which rule exactly it is, allow any court, after giving its judgment, allows a party to ask for a stay even informally and the court to grant it. So really the issue of functus official does not arise. Thank you very much.
Thank you. We will adjourn for 20 minutes. We'll be back at 5:30.
5:30. Kazi tu.
All right, that is just the court there taking a break, set to resume at 5:30 p.m. What you had there was submissions from the various advocates, and this just comes after that particular ruling by the 3-judge bench there that has now vacated the conservatory orders and sets clear path for Professor Kithure Kindiki. You did hear what the judges did say there, that the Constitution does not envision vacancy in the position of the deputy president there. Of course, various matters also did come to the fore from the various judges there. You did hear also Judge Freda Mugambi talking about the jurisdiction of the bench, matters of whether the due process was followed in regards to that particular impeachment process by the august house there, by the National Assembly, by the Senate. That is also a matter that did come to the fore. The doctrine of separation of powers was also canvassed there, and part of what has been said by the presiding judge, that is Justice Eric Ogola, is that it's a reprieve. I mean, in the event that they choose to move to the next stage, then this could particularly be sort of like a lifeline for impeached DP Rigathi Gachagua. But where do we go from here? Is this the end of the road for Gachagua from what you've deduced there, Wanjiku?
It is not the end of the road. As the court was issuing its ruling, one of the things that they've mentioned is that the main test for issuing conservatory orders, and the first petitioner, that is Honorable